So a federal court just found that the state of New York's concealed carry law, which bars concealed carry at places of worship like churches, is in fact unconstitutional, and therefore he enjoined it. So let's talk about this. But real quick before we jump into this video, if you think a ban on concealed carry in places like churches is clearly a violation of the Constitution, go ahead and hit that like button and subscribe. Also, I want to thank the sponsor of this video, which is Craft Holsters. I know a lot of you gun guys still love your classic leather holsters, and personally, I think that every gunner still needs to have at least one high quality leather holster in their inventory. Also, one of the really cool things about Craft Holsters is you can get one of these custom leather holsters for handguns with lights, lasers, and red dots. So you can blend a little bit of that old school with some of the new school technology. So if you're interested, you can check out Craft Holsters using the link down below. And if you use the code ARMSCHOLAR5, you can get 5% off of your order. How's it going, everyone? My name is Anthony Miranda. I am a licensed and practicing attorney in the state of California with an emphasis on Second Amendment rights. I've been part of Second Amendment litigation at both a state level and also at a federal level, while serving as a staff attorney with the Firearms Policy Coalition legal team. My goal with these videos is not to provide any legal advice, but instead to give you insight into the inner workings of Second Amendment litigation and what is currently going on in the battle for our Second Amendment rights. As I mentioned in the intro, in this video, we're going to be discussing the state of New York's new concealed carry law, which was found invalid in regards to one of the aspects, which was a ban on concealed carry in churches and places of worship. The case we're going to be talking about in this video is Hardaway v. Nicorelli. In this case, a district court judge in New York granted a TRO against the enforcement of the state of New York's new ban on concealed carry, specifically on the part that bans concealed carry at places of worship, including churches and synagogues. This case arose out of the state of New York's new law that was passed in response to the Supreme Court's recent decision in New York State Rifle and Pistol Association v. Bruen. In Bruen, the Supreme Court struck down New York's May issue licensing scheme, finding that it is inconsistent with the nation's history and tradition. One of the primary findings of that Bruen decision by the Supreme Court was that the government bears the burden to prove that their restriction, their law, is based in the history and tradition of our nation. But another really important thing that the Supreme Court did in that decision was they simply stated that a state like New York cannot make every single place within the entire area of the state a sensitive location or a sensitive place. A sensitive location restriction needed to also be rooted in history and tradition. However, despite this decision, the state of New York decided to rush through a new law called the Concealed Carry Improvement Act, or the CCIA. Instead of rolling back their already existing concealed carry laws, the state of New York decided to double down on their gun control and created a scheme that was even worse than the one that existed prior to Bruen. This new law in the state of New York created a more restrictive application process and then made it so that almost everywhere within the state of New York would be considered to be a sensitive place, effectively making your permit useless even if you got one. The CCIA also directly targeted some specific locations as sensitive locations, including places of worship. The relevant portion of that new law, which is relevant for this case here, was essentially that it made any person guilty of criminal possession of a firearm, rifle, or shotgun in a sensitive location when a person possesses that firearm and knows that such location is considered to be a sensitive location. Now, this law went in and added in places of worship and religious observation locations, like churches, synagogues, added those places into the definition of what a sensitive location is. Therefore, your possession or concealed carrying a firearm in those locations would be a criminal violation. So in this case, New York was sued by Reverend Dr. Jimmy Hardaway Jr. and Bishop Larry Boyd, along with other 2A organizations, including the Firearms Policy Coalition and Second Amendment Foundation. In this case, after filing their complaint, the plaintiffs filed also a request for a TRO, or a temporary restraining order, and also a request for a preliminary injunction. For those not aware, a temporary restraining order, also known as a TRO, is a protective mechanism that a party can seek from a court. The standard to be granted a TRO is similar to the standard for obtaining a preliminary injunction, with the primary difference being between the two is the duration of time that a TRO is in place, in contrast to a preliminary injunction. A TRO is a temporary placeholder to maintain the status quo of the law until a hearing for a preliminary injunction can actually take place. And the big news coming out of this case is that the court here, the judge here, granted a TRO, finding that this aspect of the New York concealed carry law, which was just put into place, does in fact violate the Second Amendment and does violate the Supreme Court's recent ruling in Bruen. So let's take a look at the decision by Judge John Sinatra, because there are some gems in this order that I actually want to point out to you guys. So the order starts off by saying that 8 days after the Supreme Court struck down New York's constitutional proper cause requirement for concealed carry licenses, the state responded with even more restrictive legislation, barring all concealed carry license holders from the vast swaths of the state. The court goes on to state that ample Supreme Court precedent addressing the individual's right to keep and bear arms from Heller and McDonald to its June 2022 decision in Bruen dictates that the New York's new place of worship restriction is equally unconstitutional. In Bruen, the court made the Second Amendment test crystal clear. Regulation in this area is permissible only if the government demonstrates that the regulation is consistent with the nation's historical tradition of sufficiently analogous regulations. As set forth below, New York fails that test. Thus, and for the further reasons set forth below, plaintiff's motion for a temporary restraining order enjoining defendants' enforcement of this place of worship restriction is therefore granted. Now, digging a little deeper into the analysis, the court found on the element of likelihood of success on the merits that this church restriction violates the right to keep and bear arms in public for self-defense, and therefore plaintiffs will likely prevail on the merits of this case. The court stated, the state argues that the place of worship exclusion complies with Bruen. The state cites 1870 to 1890 enactments by 4 states, Texas, Georgia, Missouri, and Virginia, and the territories of Arizona and Oklahoma that contained place of worship firearms restrictions. The court stated that this does not carry the state's burden. This is important because what we have been seeing a lot in response to Bruen is that states like New York are still trying to cite to later laws around the enactment of the 14th Amendment and even sometimes later, and they are trying to use those as a justification for these types of restrictions. However, as the judge in this case has already acknowledged and points out, the Supreme Court's order in Bruen was very clear. The only relevant history that can serve as a long-standing historical support for firearms restrictions are those that existed during the ratification of the Second Amendment back in 1791. So these one-off laws that existed in some states back in 1870 to 1890 were found by this court insufficient to support this ban in the state of New York on concealed carry in places of worship. The court in this case applies the straightforward Bruen test, and they asked, is carrying concealed for self-defense in a church conduct protected by the text of the Second Amendment? The court found that obviously it is. Therefore, the state of New York will only be able to restrict that conduct if that restriction has some sort of historical or traditional basis dating back to 1791. Here, the court found that New York put forward no historical laws, no historical evidence which supports this ban. Therefore, he granted the TRO in favor of the plaintiffs. Now, another really important thing that I want to point out which happened in this decision is that in this order, he did not limit it just to the plaintiffs in this case. The state of New York said that if the judge here granted the TRO, that he should limit it to just the named plaintiffs. But the judge here said that no, he's not going to do that, that it should apply to all residents, to all people within the state of New York. So this is another really solid win coming out of the state of New York. You have another federal court judge in New York finding that the CCIA is clearly a violation of the Second Amendment, and it is clearly violating the test outlined in the New York State Rifle and Pistol Association v. Bruen decision. But as of right now, this is a solid win because what it signals is when this makes its way to the preliminary injunction hearing, this judge here is likely going to rule the same way and find that a preliminary injunction should be granted because this law clearly violates the Second Amendment. So this is a case we're definitely be keeping our eyes on. If you have any questions, go ahead and comment down below and I'll try to answer to the best of my ability. You can ask me questions like Richard asked me in my last video. He asked if hot dogs are sandwiches, and this caused a huge debate in my household. So I believe they're absolutely not a sandwich. A hot dog is not a sandwich, but my wife believed they are, so that's kind of started a debate. And then there was also some discussion about how I'm weird because I put mayonnaise on my hot dog. So let me know what you guys think down below. Do you agree with this hot dog debate? Do you think a hot dog is a sandwich? Do you not? And then also the whole mayonnaise thing. I don't think that's weird at all, but maybe you guys think it's weird. So if you guys like this video and like support the channel, one of the best ways to do that is to like, comment, and subscribe. All those things help to fuel the algorithm or fuel Algorit's rhythm. It adds fuel to his jet and signal to YouTube that you guys see value in these videos and in this type of two-way news. Again, I want to thank everybody who likes, comments, subscribes, who hits the notification bell, who shares these videos. You guys directly impact these videos, impact this channel, and help me to reach and educate more people than I could ever do on my own. So as always, thank you all for watching. Don't forget to like and subscribe. And never forget, this nation is built by armed scholars, and this nation will be maintained by armed scholars.